because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? But to talk your own daughter into doing something like this is just absolutely disgraceful.
25 CR 42362, the State of Ohio versus Kenneth Carney. Mr. Carney is before the court. Mr. Carney, have you retained new counsel?
I didn't get a chance to because I'm gonna wait till after the holidays. I think he had a caseload over. He had too many cases. So the ones they were trying to call, because I got back to Lucasville December 15th. By the time I got to use the phone and call lawyers, they told me I'll call after the holidays.
Mr. Carney, this is unacceptable. I'm not going to continue to drag this case out. This case is approaching a year old already.
You're saying that's unapproachable? What's unapproachable about it? I can't, because I can't make a lawyer come to work. They was busy. It was the holidays.
Well, I'm going to appoint you new counsel today.
And then you give me a lawyer last time. He ain't even do nothing. I asked. He ain't come and see me. Still ain't got no discovery or nothing. James Moss ain't giving no discovery. I don't even know what's going on. Never came to see me or nothing. So how's it my fault?
Well, I just said I was going to appoint you counsel.
I know, I'm just
I'm
saying.
going to set this for trial here in the next month or so. This case, like I said, is almost a year old. We've had.
Yeah, but
I'm not, sir.
Sir, what?
This is not time to argue with me. I'm telling you what I'm going to do. I'm going to appoint new counsel. Now, if in the meantime, between now and 2 weeks from now, that you hire a new attorney, that's fine. But I need to keep this case moving. This case is almost a year old, and I've had it set for trial twice already.
Yeah.
This will be the third trial setting. I'm not going to continue to play this game. So here's where we are.
There's no
Mr.
game
Laux
to
is
play.
going to hand you a form. It's an affidavit of indigency saying you can't afford to hire an attorney. If you come up with the funds and you hire an attorney in the meantime, that's fine. That's great.
Yeah.
But in the meantime, I'm going to appoint someone to represent you. Are you still at Lucasville?
Yeah.
Okay. All right, so I'm going to go ahead and accept this today, and then again, like I said, if you end up retaining someone, we're after the holidays now. If you end up retaining someone, they can reach out to me and substitute in as counsel of record. That's not a problem, but I just want to keep the case moving. Okay, so this verdict form is signed by all 12 members of the jury. As to the additional finding to count one, we, the jury, find the amount of methamphetamine involved in the offense was equal to or in excess of 5 times the bulk amount, but less than the 50 times bulk amount. This additional finding is also signed by all 12 members of the jury. As to count two, we, the jury, being duly impaneled, sworn, or affirmed, find the defendant, Kenneth Carney, guilty of illegal conveyance of drugs of abuse under the grounds of a specified government facility. As he stands charged, the indictment. This verdict form is also signed by all 12 members of the jury. Does the state want the jury polled?
No, Your Honor, thank you.
Does the defense want the jury polled?
No, Your Honor.
Before I pronounce sentence, anything from the state?
Your Honor, the court heard the testimony in this case. The court's aware of the facts. The defendant has an extensive history of drug trafficking dating back to at least 2006. This was 51 grams of methamphetamine that he got his daughter with no criminal history to bring in to the Warren Correctional Institution for him, and the court heard his testimony. So we would ask you to consider all of that and impose a sentence of at least 6 years.
Mr. Brenner, anything on behalf of the defendant?
Thank you, Your Honor. I've gotten to know Mr. Carney pretty well over the last couple months I've been on this case. I think he's a polite man. I think he's an affable man. I think that he's in a situation where I know this court's well aware of the circumstances surrounding the Department of Rehabilitation and Corrections. Obviously, we think he made some bad choices here, right? I think that he sought to, I guess, alleviate his circumstances as it was. But I do know that he has, I know the court's aware, he's been transferred to Lucasville. It's a much higher security level. I know that is not enjoyable for him. I think he's already faced some consequences. I would ask this court to issue an appropriate sentence on the lower end, as I think it's notable. Obviously, none of the contraband was ever actually possessed by Mr. Carney.
Mr. Carney, is there anything you'd like to say before I sentence you?
I just apologize. There's nothing I can say. But apologize to the court. I had nothing to do with it. I still remain innocent, but
I'm sorry, I can't hear you.
I still remain, innocent to where I didn't do it, but there's nothing I can do about it. I can just apologize to the court. That's all.
The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. There are two offenses here. The court does find that they are offenses of dissimilar import and do not merge for the purposes of sentencing. Anything on that?
No, the state would agree.
Your Honor, I would ask for them to merge, but I do believe that under Ohio law that they would not automatically merge.
All right, on count one, then, the court will order you to serve a minimum term before I get to that, Mr. Carney, first off, shame on you. Just absolutely shame on you for dragging your young daughter, who you profess to love, into this. I quite frankly agree with the jury's verdict. I don't often do this. This is probably the second time in 10 years that I've actually sentenced a defendant in front of a jury, and I'm doing it for a reason. Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. Luckily for you, I think that the state, and I think we're going to do it on Thursday, her trial was set for Thursday, as you probably know. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that, who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? And that's a rhetorical question, Mr. Carney, because quite frankly, I'm not looking for a response at this, but I'm just scolding you because I think it's shameful for a parent to drag, and we see these cases all the time where people, they talk these young women, but to talk your own daughter into doing something like this is just absolutely disgraceful, in my opinion. Your record dates back to 2001, your criminal record. So you have a criminal history of over 25 years. This is your third conviction for aggravated trafficking. 3. You're not learning anything. So the court is going to order you to serve a minimum prison sentence of 5 years, a maximum prison sentence of 7.5 years. That has to do with Reagan Tokes, as you probably are aware. And on count 2, the court's going to order you to serve 36 months, that to be served concurrent with count 1, but consecutive sentence to your current sentence. So I'm adding on 5 to 7.5 years to your current sentence. The court does find that a consecutive sentence is necessary to punish you and to protect the public from you. It is not disproportionate to the conduct or the danger that you pose to society, and this offense was committed while you were already incarcerated in the Department of Corrections. You have 0 days jail time credit. You are subject to a mandatory period of post-release control on this, as you probably already are on your other one, which means that when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. You do have a right to appeal the jury's verdict and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. You can't afford to pay for the transcript or anything necessary for your appeal. That can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nichols.
Nothing further, thank you, Your Honor.
Mr. Brunner.
Not at this time.
All right, that's all. Thank you. All right, ladies and gentlemen, at this time, we are obviously finished, and I oftentimes don't ever do that. I've done it one other time that I can think of. I will explain that to you in the back.
How long it take for the appeal to come in?
Well, so I'm gonna file it. It'll, like we talked about, it'll probably take a couple weeks to a month with the transcript ready. And then from there, your appellate counsel will have, 46 weeks to file their brief. Okay? Oh, that's for what? I'll file that.
Are you able to take us off the record?
Number 25 CR 42361, the State of Ohio versus Kalia Carney. Ms. Carney is before the court with her counsel, Mr. State and Ms. Nicholson, on behalf of the State of Ohio. We are here for sentencing. There was a pre-sentence investigation prepared. Anything on behalf of the state?
You're on note for the record that counts 1 and 2 would merge for purposes of sentencing, and the state will proceed on count 1. Beyond that, we have nothing.
All right. Anything from probation?
Nothing further, Your Honor.
Obviously, the court's well aware of the circumstances in this case, having sat through the trial of the co-defendant. We would just like to point out that my client has no record prior or since this incident. She was pressured clearly by her co-defendant into doing this, and just wasn't strong enough at that point to deny him. And that is how this happened. She has been cooperative. She testified at trial, which was very difficult for her. She has a lot of family support. Her mother's here with her today. Her other family members have come with her in the past. She has strong family support in the community. She has 2 infants for whom she cares and has the primary responsibility to care for. She is employed. She just got hired and just started working full-time. I think it's full-time. Yeah. This last week. We would ask the court to strongly consider not removing her from her responsibilities to her children, allowing her an opportunity on probation to address the issue she does have with marijuana use, which she realizes is something she can't do, and she's under the supervision of the board.
Thank you. Ms. Carney, is there anything you'd like to say?
Yeah, say that I was naive in this situation, and I'm sad that we couldn't meet a different way, but I did learn from my lesson, and I learned from it, and I just want to do better and get myself back together.
Who's with you in court today?
My mom.
Mom, anything you want to add to any of this?
Yes, if I may, please.
Yes, please.
Marilyn Hall. Their dad has been in jail most of their life. I think he kind of used my daughter. He got the closest with her out of all 4 of my children. And I went through abuse with him, all types of things, so we've all been through it. I tried to keep her away, but just trying to have that relationship she never had. The other 3 kids didn't get that close with him. And I'm so sad about this whole situation because she's not like that. She worked with me being a DSP. She lost her job, everything. It's just been a lot.
All right. Well, thank you. Ms. Carney, is there anything you'd like to say?
Yeah. I'm just tired. But I'm ready to take my accountability and learn from it and just push through and make everything better and at least try to give me a career again.
Okay. All right, the court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing. The court does find, based upon all of the information, Ms. Carney, and I obviously sat through the jury trial of your father where you were a witness on behalf of the state. The court is going to find that you are amenable to community control. So I'm going to place you in the community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
Now, I know that marijuana is something that's part of your life right now, but you have been diagnosed with a substance use disorder involving marijuana,
Yes.
so I'm not going to allow you to continue with that. Do you
Yes, Your
understand me?
Yes, Your Honor.
All right. I am going to order you into the treatment for that substance use disorder. You're ordered to complete the thinking for a change course. You're ordered to get and maintain full-time verifiable employment, which apparently you already have, so that's good. You are trespassed from all Department of Corrections properties. So you're not permitted on any property of any prison or state-run facility. Understand that?
Yes, Your Honor.
And you're to have no contact with Kenneth Carney. I know he's your father, but the contact you've had with him did not end well for you. So I'm going to forbid you to have any contact. You'll be on the no contact list at the prisons. You can't go to see him, and all of the phone calls are recorded. So if you try to have contact with him, they're going to find out. Okay, so don't. Right now, you just can't. He dragged you into a big mess, and this was very unfortunate, and I feel very bad for you. But I don't know how else to say it, but a good father would not have involved his daughter without a criminal record into this type of criminal enterprise.
I don't care what benefit there was to him. That's not a very good idea in any case. It shocks me, to be honest with you. And then for him to force you to testify against him actually makes it even worse, in my opinion. But I am also going to find you indigent for the purpose of any fines, costs, or other financial sanctions. Do you have any questions for me?
No.
All right, now I know you're still continuing to test positive for the marijuana. I want that to stop, so they're going to start checking your levels and making sure that those levels are going down to 0. Do you understand?
Yes, Your Honor.
Charlie, thank you.
Best of luck to you.
Thank you so much.
Anything for me, right?
Thank you, Mr.
Versus Adrienne Johnson. Ms. Johnson is before the court with her counsel, Mr. Gibbs. Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. Ms. Nicholson, anything on behalf of the state?
Your Honor, the state did reduce these from a felony of the 2nd degree. This is not Ms. Johnson's first time participating in the conveyance of drugs into a prison. The court is aware of the facts of this case from her co-defendant's trial. She facilitated the transport into the institution of 51 grams of methamphetamine. We did reduce it out of that mandatory time, but we would ask the court to impose a 24-month prison sentence. It's my understanding she has 6 days of jail time credit, and there is a $35 reimbursement to the Ohio State Highway Patrol.
Anything from probation? Mr. Gibbs?
Yes, Your Honor. Well, the prosecution has certainly laid out, and this court is well aware of the facts and charges of this case. I would briefly ask the court to take a closer look at the picture of who the defendant is as a person at this point. Ms. Johnson is 37 years old. She's a local of Cincinnati and grew up in the Mount Healthy area with her parents, 3 sisters, and 1 brother. She used to be a cheerleader and track player. One of her memorable moments from that period of time was graduating early from high school on the honor roll and actually meeting President George W. Bush in 2006 and receiving the Presidential Awareness Award. I would like to take a moment to note many of her family members, as she is well aware that she is being incarcerated today, she purposefully requested several of her family members not to attend just to have that be kind of a traumatic thing. That's certainly not a lack of love and connection, and I have received numerous correspondences from a mother, godmother, an aunt, and her son concerning that. I just want to note their absence. Her uncle and father are present. As of 2023, she and her children were actually living in a shelter, and during that difficult time came through, and as of more recently, prior to this case, had obtained a townhome. She has 2 sons, Demarius, which is 16 years old, and Demario, which is 13 years old, who's also been diagnosed with bipolar and ADHD. She helps care for her grandmother, who's 79 with bad kidneys and is a breast cancer survivor. She also helps her niece, Riley, who has severe mental delayment and mental processes. A regular theme that comes through family correspondence is that she's kind of the glue that holds the family together. Being a high school graduate, she has attended 3 semesters of college at the Jefferson Community College in Louisville, studying psychology. Unfortunately, she had to drop out due to a family living arrangement situation change where she was living with a relative which moved. She was planning to start school this August to become a peer advisor. Her current employment, which she just ended as of 3 weeks ago, as a cashier and runner in the general front house responsibilities at an Arby's. She also works part-time catering with Scott's Barbecue since 2018, showing a continued desire to provide for her family and be employed and be a productive member of society. She deals with a depression diagnosis. There was some significant trauma in her life. Heartbreakingly, in 2008, she gave birth to her daughter, who died in her arms suddenly and from a lung issue. Just 2 weeks ago, her 47-year-old cousin, with whom she was very close, passed away at the age of, again, 47 from a heart attack. And she also deals with severe PCOS, which requires medication to avoid excessive bleeding. She does attend worship at the Truth Temple with her father, and in our discussions, which we have had many leading up to this point, she does show sincere acknowledgement of this situation and significant regret. The greatest regret that she has repeatedly expressed to me is not being able to be there for her two boys, and she recognizes that that's her fault and that that's not, she's taking full responsibility of that. She would clearly state she's not the person she was 2 years ago when this all occurred. If I could briefly just state from a few of the letters from her grandmother, noting, she'd like to say that she's a person of genuine kindness, compassion, and character, and she's personally witnessed her true remorse. Her son Demarius states that his mother always encourages me, gives me advice, and reminds me to keep going. Everything she does comes from a place of love. I truly appreciate the sacrifices she has made to give me the opportunities and help succeed. And then finally, her grandmother states, I'm fully aware of her history, that this is the second time she's facing incarceration and seriousness. I do not take past or present mistakes lightly. However, I'm asking this because I've been firsthand witness to the remarkable, responsible, dedicated woman she's been over these last 9 years, working hard and resiliently for her family. And then finally, from her mother, I hope to provide insight into her character and the effort she's made to build a better life. Since her mistakes, my daughter's worked hard to change the direction of her life. She's secured steady employment, maintained that responsibility, demonstrating reliability and a strong work ethic. She's also established a stable home where she's raising her 2 teenage sons. Providing for them and being a positive presence in their life has been her highest priority. Your Honor, looking at the whole picture of who the defendant is, I believe may lead this court to consider reasonably an appropriate sentence. We respectfully ask the court to consider the 9-month sentence, given all of these factors today.
Thank you, Mr. Gibbs. Ms. Johnson, is there anything you'd like to say?
I just wanted to add, I'm aware of my actions and I apologize, and I just pray that everything works out the correct way in the justice system today.
Ms. Johnson, I'm a little bit confused because you entered a plea of guilty, but yet in your statement you continued to say that you had no knowledge of taking the substance into the facility.
Yes, sir. I had to talk to my attorney because I was confused on how they was charging me with specific things like intent, and I was just confused because I didn't tell her, to do.
No, but
things.
certainly the messages between you and Mr. Carney clearly established that you were involved and knew what was going on. Do you deny that?
If I could elaborate one thing, Your Honor, briefly, because we've had many discussions on this. As we went through the discovery and evaluated her case, obviously a large component of the prosecution's case against her is the testimony of the co-conspirator.
Well, I disagree with that. I sat through Mr. Carney's jury trial. I heard Ms. Carney testify at that trial. Mr. Carney came up here and he testified and gave some goofy story that didn't make any sense at all. But the messages between you and Mr. Carney clearly established that you knew what was going on and you were part of this. You were up to your neck in this. And on the other part of that, this is the second time you've done it. I mean, you basically tried to explain this away as you were just giving a friend an old friend a ride to see her father in prison. She apparently tried to take a substance into the facility. Not apparently, she did. She took it in. I had no knowledge of her doing so. You gave her an old bag of
Flaming Hot Cheetos.
Flaming Hot Cheetos. That clearly was not Flaming Hot Cheetos because the bag was opened and it had something else in it. I'm just kind of confused. And then there was even, I believe there was a follow-up after she dropped it off in the prison. There was a follow-up call or text between Mr. Carney and her. Wasn't there something?
I know that Ms. Carney confirmed that he had, that.
But that was after
the fact. But there were certainly.
So I'm going to give you an opportunity to try to explain those facts away.
No, like I said, he explained everything to me in detail, so I'm not denying anything. Like after that, me and my attorney have talked several times since the PSI, and he went into detail with everything. Like I said, the last attorney didn't explain a lot of stuff. It was some pages that I didn't get in it that he did give me to show why the charges were filed. And like I said, today I take accountability, and that's all.
All right, anything else you want me to know?
No.
All right, the court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Ms. Johnson, I have to tell you, we have a problem in our state, in our country, with people who are incarcerated getting illegal drugs, and this is the number one way that it happens, is that they're brought in from the outside by a family member or a friend through a visit, and it's got to stop. The other problem is that this isn't your first time. You've done this before. You've done this exact same thing before. So, while you're having any communication with anyone in the Department of Corrections, I believe that ODRC has you red flagged, so you probably will never be permitted. But that's between you and them. The court does find that a prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. So, on count one, the court's going to order you to serve 18 months in prison. On count two, the court's going to order you to serve 12 months in prison. And on count four, the court's going to order you to serve 12 months in prison, those to be served concurrent with each other. You have 6 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. At this time, the court is going to revoke your bond and remand you into the custody of the Warren County Sheriff's Office for transport to the Department of Corrections. There was a deputy